engagement. You are over the target. You are authorized to fire at will.
Well, thanks for stopping by for what is ultimately the actual season premiere of TC and Friends Monday Night Musings. You guys are in for a treat. I have a returning guest, Tom Gallagher. He's the esteemed criminal defense attorney. I know everybody out there, settle down. He's a criminal defense attorney. He's one of the good guys. I keep trying to tell you guys the criminal defense attorneys are on the right side of the conversation that we should all be having, and we should all be very thankful for them. Especially Tom. He's literally on the right side of these arguments, and has a storied career here in the state of Minnesota to back up that statement. So, but he's been on before. We've talked about marijuana legalization in the state of Minnesota, and we've talked about jury nullification, and those will be linked in the description of the video. But this is the actual season premiere of TC and Friend Monday Night Musings. And so I'm going to give a big shout out to my show producer level supporters. IMAV from over on Subscribestar, who picked that top tier, and the Angry Vet from on YouTube, who's also done a massive amount of support for the channel in various ways. So they help keep this going. To all the channel members, you guys, everything that you do by being a channel member, it's insurmountable how much of a blessing it has been to the show, to me, to what I do. And thank you for enjoying and allowing me to enjoy the break from the beginning of January till now. I do a lot of content throughout the year, and I just need some downtime. And I decided that the stuff that I've been covering with Pam, with what happened with her, with the illegal entry into her home by Plainview Police Department back in 2022. I think I have the year right. Pam will correct me if I got that wrong. But I've been going over just a massive amount of videos, audio, and audio recordings and video recordings of interviews and conversations and whatnot that stem from the investigation, where they found that she had done nothing wrong. We're still working on that, but the stack just goes from this every day to this. And so we're going to be leading in more this season with that. Working on my first guest for the Libertarian Lowdown. Hoping to bring in some heavy hitters on Defend the Guard for that. And we've got a Defend the Guard rally coming up in the middle of March, coming up very, very soon. It's going to be here before you know it. I think it's March 15th, if I remember correctly, but I don't quote me on that because I don't know for sure, but we're going to be working on all of those. So many of you have been paying attention across the United States, actually, because I've had people asking me, what the hell is going on in Minnesota? I heard your Supreme Court just made it lawful for cops to pull you over and search your car on a whim. And the Fourth Amendment's out the window in Minnesota. And it all stems from a case from a couple of years ago now, where a gentleman was pulled over and he had a pellet pistol stashed under his front seat. And the trial court, and Tom will correct me if I get any of this wrong, ruled in his favor, saying that part of it's out. You don't get to do that. And the appeals court and then Minnesota Supreme Court offered their opinion on this, basically defining a car as, for lack of, to use Tom's statement, to make the car's invisible. The car is technically invisible, and therefore, when you're in a public place, cops can go through it. Now, does it raise some questions and raise some concerns? Sure. But is it a Fourth Amendment issue on the way that we're being told we have to look at it? And we're getting a lot of opinions out there from people that, and some of it's shocking, frankly. I'm very shocked because normally the crowd that's very much on board with backing the police, no matter what, at all costs, are some of the people that are raising concerns. And so, as an anarcho-capitalist, Miesian, uh, Rothbardian type, I'm like, anything we can do to get people to start questioning the all-encompassing, all-powerful extension of the police into our lives, law enforcement into our lives, is not necessarily a bad thing. The question is whether or not we're steel manning the arguments. And as soon as this came out, and Tom can attest to this, as soon as this came out, I reached out to him and said, "Hey, we need to have a conversation," and he was happy to do it. So, without any more fumbling along in this conversation, I'm going to bring my esteemed I call him friend. He doesn't know this. I do. I call him friend to other people. I say, I have this friend, Tom. So just to ruin your street cred, I call you friend. So I can't be held responsible if people hold that against you. So thanks for doing this. We're for those who think that you're seeing this live. Obviously, it's way too bright for this to be an actual Monday night. So we're recording this the day before Monday Night Musings and putting it out. So pretend like it's Monday, Tom, and tell me, are we dead? Are we all going to die now? Is this the beginning of the police state in Minnesota, and we all need to worry that they're going to search our garages without our permission?
I think that this Minnesota Supreme Court case that came out, I think it was last Tuesday, a few days ago, less than a week ago. It was filed on February 19th, 2025. State of Minnesota versus Kayab BB. A kind of an ironic name because the guy's name is BB
Yes.
and the case involves a BB gun,
Yeah.
right? So, wow, what are the odds of that, right?
Yeah.
Um,
Minnesota
but
criminals in the courts, they're a gift that keeps on giving.
yeah, right, right, right. So this case came out and it got a lot of attention, and a lot of us aren't super surprised by that because a similar thing happened maybe 6 months ago, a little bit less, when the Minnesota Court of Appeals came out with their opinion, which is pretty similar to the Minnesota Supreme Court opinion, in that the intermediate appellate court, the Minnesota Court of Appeals, is between the trial court level and the highest court, appellate court, which is the Minnesota Supreme Court. So they reviewed the district court judge, his opinion, which ruled in favor of the defendant. The district court judge said that if you read this statute, this carrying in a public place statute that covers rifles and shotguns and BB guns, interestingly. And by the way, maybe I should mention the name, the number of that statute is Minnesota Statute Section 624.7181. And that statute, you can type that into your favorite search engine, and it should come up at your number one result. The Minnesota legislature has the statutes online, easy to access.
What was that statute number again?
624.7181. And your search engine should bring up the 2024 version, which the version in the case might be a prior year, but if you look at the bottom of the statute, you can see it was last amended in 1994, so it hasn't changed since 1994. That's easy to see just by looking at the statute there, right on the legislature's website. So the statute, the 2024 version we're looking at, is the same as the one that the district court looked at for the date of the search of the car, and when the police found the BB gun under the guy's seat, the defendant's seat of his car. His car, they said, was in a public place. I think it was actually a driveway, but we can just say that we can skip over that and say, well, they're considering that a public place or public roadway. So if you're on a public roadway or a public place, because of the way the Minnesota Supreme Court decided the language of the statute, they interpreted that language to mean that if your car is located in a public place, then it doesn't matter that the that your items, your prohibited items, which are your shotgun, your rifle, or your BB gun, are inside your car, that's still a public place. So you need to have a carry permit, or you need to take the required steps to store it properly in a enclosed case, and or in the trunk of the car, or both if you want to be very uh, belt and suspenders
Yes.
sure that you're, which is what most people do. Like, hey, I don't want to get in trouble with the cops, so I'm going to do both of these things. I read the statute closely the other day. Like, wow, it does say or though. So if I ever have that one of those cases where it's one or the other, I think I'm going to win that case. But
You'll argue it on the or.
right, well, the law does say or,
Yep.
so they could change the law, and if until they do,
Let's not give them any ideas right now,
we
Tom.
have a right to rely upon it, don't we? I think we
Yes,
do. So
let's not give our legislators from either side of the House or Senate.
So, so what the Supreme Court did in this case was they interpreted that statutory language that you've highlighted in yellow there, the definition of public place. And what you'll notice in that definition, it doesn't say anything about motor vehicles at all in there. It talks about publicly owned land
Right.
and privately owned real estate, like, but it doesn't talk about motor vehicles at all, one way or the other. So the district court gave the benefit to the defense, which I personally agree with. If it's ambiguous, I think the defense, there's a rule of statutory construction that since the government writes the law, if it's not clear, you have to interpret any ambiguity in favor of the accused, because the government can just rewrite the law to make it more clear next time.
I think that's
Um,
really key. What you just said is that you have to interpret it in favor of the accused.
That is one of the
Yeah.
principles of statutory construction.
Yep.
There are many principles of statutory construction. And sometimes, the court will favor one over the other. Like another one of them is that we should interpret the statutes consistently with what the legislature intended. I think that that's more appropriate in the civil area than in the criminal area, because in the criminal area, due process requires that the government give us fair notice of what we must not do in order to avoid a criminal penalty. And is it fair notice when it's unclear or ambiguous? I would say, no, it's not. It's not fair notice. They need to spell it out really clearly so that a person of average intelligence could read it and understand, oh, I can't do that or else I'm going to get, thrown in jail. And this statute does not do that, I think. But so, that was the debate that was had, that type of debate and more. Was presented to the Minnesota Supreme Court. They made their decision. And the reality is we're now stuck with it because they are the highest court and there is no higher court. This cannot be appealed to the federal courts because this is a Minnesota state statute interpretation. The federal courts are not going to overrule the Minnesota Supreme Court on that. They might on the Fourth Amendment if it was a search and seizure case, which it wasn't. And that's an interesting point because most people who read the headline, who don't read the case, they wrongly believe and assume that this case is about searching your car. It's a public place. The cops can now more easily search your car. That's not true. Not based on this case.
So give us an example. And I know that it's very easy for us to do the speculative kind of conversations. What would have made this a Fourth Amendment case? Can give the audience and the people who are struggling with this right now, who are hearing what you're saying, going, well, isn't it always about the Fourth Amendment? And we could talk about Second Amendment
Yeah,
issues,
in order
but
for it to have been a Fourth Amendment case, and I have lots of Fourth Amendment cases, and I'm sure every criminal lawyer does. It's a very common thing to raise the Fourth Amendment, which is the Fourth Amendment to the United States Constitution that talks about there shall be no searches without a warrant, which the courts have interpreted to include probable cause to search a car, which they sometimes refer to as an automobile exception to the warrant requirement, which is really a misnomer because I've won cases where there was no search warrant to search a car, but that's relatively rare. In most search circumstances, they're probably going to be able to search a car without a warrant. Um, you know, 9 times out of 10. So, but the defense would have had to raise the Fourth Amendment issue or the search and seizure issue, and they did not raise it in this case. So the fact that they didn't raise it to me tells me that they must not have thought there was anything there that any kind of issue that would have been a winner for them, or they would have raised it. But they didn't raise it, so we don't really need to look any deeper into that.
Do you
It's
think
not.
it's I'm not going to apologize for cutting you off because I did it,
That's
right?
okay.
Um, do you think that people will hear this and think, well, but isn't a search always a search no matter what? And so doesn't this, don't you have to make a Fourth Amendment argument in some of these? Because
Well,
I
I
think
think you
where
can
a lot
think
of
of it
people
in
struggle.
think of it as maybe one way to simplify this and make it more, simplify it, make it easier to understand. Think of it as there are two steps or stages involved. So step or stage one would be a search, and then stage two would be, well, given the evidence that was found after the search, was there a criminal law that was violated? Okay. So if the police search a car and they did not have probable cause to search a car, they did not have consent to search a car, then a judge would probably rule the search was illegal. And I'm simplifying, skipping over things, assuming things, but that's what I just said is true.
Right.
If the defense says, hey, that was an illegal search and there was no probable cause and there's no exception like consent, normally police try to get the driver to consent to the search. They're trained to do that, and they will usually the driver will give them consent. And by the way, don't give police consent to search. But
If they want to search bad enough, they'll come up with a reason they don't need your permission.
maybe, but if they do that, yeah, that's what they want you to think. They want you to think, well, it's inevitable. We're gonna search your car, so are you gonna consent or not? Like, uh,
You did hear him say it though, folks. You never give consent to a
the
search.
correct answer is no. No matter how inevitable it appears, never give consent to search. Because if you don't, then your lawyer might be able to win your case later.
On a Fourth Amendment issue.
Yes, like I mentioned a case before we started where I saved a guy from 8 years in prison because I got a search ruled illegal, a car search after they towed the car to a government building and had all the time in the world to get a warrant, but they didn't bother to. And I got the search suppressed, and my client went free, even though he had like 80 kilos of weed in his van,
Oh,
got off scot free because of an illegal search. But so
we're
that's
renaming that now to "Got Off Tom Free." So
yeah, right. So in criminal law, we can look at, what we sometimes call pretrial evidentiary issues. Was the evidence legally obtained or not? If it was illegally obtained, then it's more important to prevent the police and the government from profiting by their corrupt and illegal behavior. So the courts will not allow them to use the evidence. And
right.
if they don't have any evidence, then there's no probable cause, or there's no evidence to support the charge. That's a lack of probable cause. All the charges could be dismissed.
So not
However,
being in the courtroom,
but this
for this argument, clearly the defense never brought this up
that's
because
the
they
thing.
had to have made a tacit admission that the search on some level was either
Right.
granted permission or was legal.
Right. Bingo. So yeah, I don't know the details of that, but I have many cases where I don't raise a search issue because I know there's a 0% chance it will work. So why raise it? You're not gonna if you have a decent issue, you don't want to dilute your strong issue with some really horrible loser issues because
Right.
judges are human. They only have so much time and attention to pay. And if
And
they pay
patience.
attention, if they spend 50 minutes out of an hour on BS, and then hidden in there somewhere, you've got a gem, they're not going to notice the gem because you've polluted it with all the garbage. So you want to give them your strong issues. You don't want to give them weak issues. Unless that's all you have, maybe okay, all you got is a weak issue, you give it a try. But so they didn't so that in this B case, there was no search issue. The defense didn't raise a search issue. Therefore, the courts did not rule on it because it wasn't presented to them. The
They
trial
couldn't
court
even.
judge, the Court of Appeals, the Supreme Court, none of them talked about Fourth Amendment. None of them talked about search. So this idea of public place even though in the public mind they link it to search, it's not legally. It's not related to search and seizure. It's not related to Fourth Amendment. They're talking. So if you have a carry permit, like I have a carry permit, I don't. Do you have one?
No, not anymore.
Okay, okay. So
Not
I have a
not
carry.
right now.
I have a carry permit to carry a gun in public place. Okay. So if I did not have a carry permit, like I could carry a gun in my house, which is not a public place. I can carry a gun all over my house without a permit, no problem.
In your
Anybody
yard,
can, unless I'm prohibited from possessing a firearm, But
right?
yeah. So, but if you're in a public place, then in Minnesota we need to have a carry permit to carry a gun.
Right.
Normally, unless we're a police officer, some oddball exceptions that hardly ever apply, but to most people. But so this is the type of the public place that this case talked about, was the public place. Are you committing a crime? So if I'm in my house carrying a handgun and I don't have a carry permit, I'm not committing a crime, at least not the crime of carrying in a public place. Why? Because I'm not in a public place. So that's what the defense raised in this case. They said, hey, he can't be guilty of carrying in a public place because he was carrying inside of his car. And, his car was in his garage, which is part of his house. It's not a public place. And then he drove out of his garage and the gun never left his car. So his car is a public place. The interior of his car is his private, non-public place. So therefore he doesn't need a carry permit to carry it inside of his car. And the trial court judge agreed with that, because if you look at the statute, it doesn't really say one way or the other. So you give the benefit of the doubt to the defense. That's a very solid criminal law statutory interpretation principle.
And the trial court agreed.
Yes, exactly. That's what I just said. So, but the Court of Appeals, they decided, they disagreed, and we could get into the whole debate there, but in a way, it's a waste of time because the Supreme Court has already decided it the way we don't like. And so we just have to live with it now, I guess, unless we can get the legislature to change the law. And by the way, the Minnesota Gun Owners Caucus is working on legislation, a bill. They're working with legislators right now to write a bill that would do just that, to change the statute, to change the definition of public place, so that it would not include the inside of a car. So the legislature could fix this if they wanted to, no problem. It's not like it's sometimes when the Supreme Court interprets the Constitution, the legislature can't do anything about it because the Constitution, like the Second Amendment is the Second Amendment. If the statute is unconstitutional, they can't fix that usually. They're just going to have to live with it. But in this case, it's not a constitutional issue. It's a statutory language interpretation. So the legislature can change the words in the statute just by passing a bill, and then they could fix it that way. But it's not this case itself. The opinion does not address search and seizure law at all. But we could still, use it as a launching pad to start thinking about and talking about search and seizure issues, even though the case doesn't address them. For example, other states have what we sometimes refer to as castle doctrine laws that are more broad, more expansive than Minnesota. In Minnesota, we have a castle doctrine law. However, it limits it, and what that means is you don't have a duty to retreat in Minnesota inside the four walls of your home. You don't have a duty to retreat. Outside, you do, unless you are acting in self-defense of another. So there's two exceptions in Minnesota. One is defense of another, and because so let's say you're with your kid and somebody attacks you two. You and your kid are walking down the street. You get attacked by a criminal who's going to do you physical harm. It's going to kill you or cause you serious bodily harm. So you have a duty to retreat. So you run like hell. Your kid's kind of short. They've got short legs. Your kid can't keep up, right? So the guy kills your kid. So that would be an absurd result. So the Minnesota courts recognize that. They're like, okay, well, you don't have a duty to retreat if you're defending somebody else, which is a type of self-defense.
Which is something that a lot of Minnesotans don't understand. They do not. And I think part of it is especially the more firearms friendly culture, people who do believe strongly in self-defense and defense of others. um, tend to, and I say this as graciously as possible, tend to overreact to hearing some things about duty to retreat in Minnesota, especially, and uh, go, well, that means I can't do anything. So what's the point in even having a firearms permit if, if I always have to run away no matter what?
Yeah, I mean, that's a bigger topic, almost one
Yeah,
deserving of another discussion. But
you
I
heard
just
it here,
wanted to,
folks. Tom
I
just
did want
committed to
to,
another show.
but I wanted to bring in the whole idea of the castle doctrine because even though Minnesota does not include the automobile, your car, most people think of their car as part of their private space. In fact, some people live in their cars. I talked to a guy this week who's living in his van. So I don't mean, is that, I guess that's homeless or maybe not. It's kind of in between, like living in a van down by the river, right?
It's a whole trend now. People are actually just living in like
Yeah.
converting vans and buses into houses. So
But even people that don't live in their cars literally, I mean, I've seen people's cars, it looks like you look in their back seats, like, wow, you've got laundry back there. You've got like
yeah.
your lunch containers, that you probably should go wash once in a
Yes,
while.
please, just once.
So, people do kind of live in their cars. And some people are neat and tidy about their cars and they take great pride and they're very, keeping them spick and span. But people do think of their cars as part of their private personal space. So, if the law does not align with what we as a people in our culture, our shared community, if we don't believe that the law reflects our values, we can change the law through the legislature. And the courts, when they interpret statutes, they're trying to read between the lines and fill in the gaps that the legislation, that the statutes don't address, like this one that talks about public place. It doesn't address motor vehicles. So the
Yeah.
judges are, the trial court judge went one way and the appellate courts went the other way. Well, that right, the fact that they didn't agree with each other tells you that either position has an argument that is plausible, at least to some people. So if we as a people think, you know what, our cars are our private place, we should probably change the statute. And if we did do that, even though it would not have a direct impact on search and seizure law, it may have an indirect impact because it may make us think, you know what, maybe since if cars are a private place for purposes of the carry law, the weapon carry permit law, maybe courts should be a little more respectful about the inside of a car. Maybe they should require a warrant more often. Maybe they shouldn't be so easygoing about inventory searches after the cops tow your car on some pretext like a parking ticket. Yeah, you got a parking ticket, so we're going to tow your car and we're going to search it because once we tow your car, there's a legally recognized loophole called the inventory search after we
Mm.
tow the car.
Do you look at this as, boy, and I hesitate because like I said, I just don't like giving anybody any ideas, but um I know you're well aware, but a lot of people talk a lot about Terry v. Ohio and the precedents that really created, um, in how you can be searched, how you can be approached and whatnot by law enforcement, just walking down the street. It really kind of started to raise the kind of that albatross around the neck of the legal system of, are you a stop and ID state type um, uh, argument or discussion. But Terry v. Ohio clearly did set some kind of scary precedents, um, depending on the jurisdictions you find yourself in. Is there a potential for this ruling to somehow go kind of cattywampus on us as the people, we the people of the state of Minnesota, and open the door for law enforcement to do stuff that they can't already do?
Not really. I mean, not directly, definitely not directly, because this case literally had nothing to do with the Fourth Amendment at all. Terry versus Ohio was a Fourth Amendment case. And by the way, at the time, it was a pushing back against police power to search people. So it was a a case that was viewed as limiting police, not empowering them at the time. So, but it does set kind of a low bar for when police can do a pat down search for their safety. They still need a reason to um, intrude upon your liberty. They have to have some reasonable articulable suspicion of criminal activity or
Right.
an observed legal violation in order to be able to stop you for even a pat down search. So, and that was the limitation. Before that, I think, cops would just, they have the gun, they have the club, and you better stop, and they're
Yeah.
going to search you. So
Yeah.
Terry was kind of a
You don't argue
limitation.
with them.
Yeah, I think Terry said, "Hey, you can't do that anymore. There's no more shakedowns by cops because they're not just government thugs anymore. They're now going to be limited by the Constitution." So that was kind of the Terry versus Ohio was kind of an advancement of people's rights. The courts empowered people to be protected from police.
It's just
Uh,
the police learned how to argue their reasonable articulable suspicion better.
Yeah, I guess so. I guess so. I mean, I think it is a low bar, but so I think if you ever I've watched some of these videos of people open carrying firearms and they get into debates with cops. They're kind of some of them are kind of entertaining. I'm not sure I would be personally one up for that, but it's interesting to watch. But they do need some kind of you know, reasonable articulable suspicion of criminal activity. So they see me open carrying a gun and well, that's not illegal. So what's the suspicion? So, they do need some suspicion. But this particular case, the State versus B case, did not have anything to do with that whatsoever. Not even.
No, and I wasn't.
It does remind us. So the people who see
Yeah,
the headline is like, oh my gosh, public place. That reminds
that's
me
why I
of.
asked. Yeah.
It's like tangential thinking. Like if you say dog, then I think cat. Well, wait, no, we're at a dog show. We're not at a cat show. But yeah, but
A and B don't
dogs
always
remind
lead
me
to
of
C.
cats, though,
Yeah.
right?
Yeah. A and B don't always lead to C.
Yeah.
Sometimes it's just A, sometimes it's just B, and C never comes into the
But
equation.
it's such a powerful thing. Like I'd say most people, when they first hear the headline of this case, they automatically jump to search and seizure, which is completely wrong, but they all do it.
No,
So,
my gut reaction in conversations with somebody the other day was, boy, the boy who, and I think for me the initial gut reaction had less to do with even the Fourth Amendment and more to do with the Minnesota Supreme Court going, no, your car is a public place, and I'm like,
and
that
that's
is
another
Fourth.
thing that I think that's kind of an interesting thing right there, what you just said, because the Minnesota Supreme Court didn't literally say that. What they
Right,
said was that the Minnesota legislature said that.
right.
So the Minnesota Supreme Court is trying to, it's kind of like if you have a medium that's trying to talk to the ghost of your ancestor or something. That's like the Minnesota Supreme Court is the psychic medium. And the ghost of your ancestor is the legislature, right? So
The John Edwards of the Minnesota courts.
yeah, so the Minnesota Supreme Court, they're not writing the law, they're not making the law, they're interpreting the law that was written by the legislature. So whether they got it right or wrong, we can disagree or agree on that, but it doesn't really matter because they're the final authority. The only way to overturn their view of it, their interpretation, is for the legislature to step up and say, you know what? You got it wrong. We're going to add a few words. And in my article that you had up a little while ago, I have some suggested language that could be used in an amendment. So I'll be interested to see what the Minnesota Gun Owners Caucus comes up with our, liberty-minded legislators that are willing to write and sponsor legislation this in 2025 this year. Hopefully this within a couple weeks, I would guess, to fix this case. Because that's the real answer. I mean, it's fun to talk about it, but we could actually change the law if we got behind this new statute, this new bill in the legislature to change the law.
Let me ask it from this direction then. Since the Supreme Court said no, the legislative body, they left the interpretation open. They kind of made it clear that your car technically is a public place, even though they didn't say it in those words. That's what they're interpreting. Would this, not this case, but would the legislature going in now and changing that, amending that, were a similar case to come forward as to, Minnesota versus BB. Right. Minnesota versus BB, is that what it? Yeah, BB.
State of Minnesota versus
Or yeah.
B. Yeah, I think his middle name
Would
is.
the
I'm not
would
sure if
the
it's the last name is BB or just B. It might be. I think it's just B, but
would the Minnesota Supreme Court or the appeals courts or even trial courts, would they have now this ruling to check against what the legislature said and said, hey, the court said that your car is a public place and that now you've changed this, but we still have a precedence here.
no, that's a good
No.
question. But the answer would be no. So if the Minnesota legislature amended that statute to clarify, like the language that I suggest in my article, and I guess as long as I said that, maybe I should go
And
over to.
folks, it's like a 5 to 6 minute read. It's not a terribly, it's not like reading on my Substack, folks. You don't have to commit an entire week.
Yeah. So um, the key language, it says, quote, public place, quote, does not include a person's dwelling house or premises. And then the added language they could add is a person's motor vehicle, comma, and then the existing language, the place of business owned or managed by the person or land possessed
Right.
by the person, unquote. So the new language would be to drop in there in that list of private spaces that are not public would be a person's motor vehicle. So if they added that language in, that would effectively overrule the B decision by the Minnesota Supreme Court.
Because, and there again, people have to understand this. They only have the power to interpret what's there, not insist upon a removal of what's there, even if it's based on a decision that they made in the past. They
Right.
can't lean on their own precedents to say, "Oh, we've already decided that it is a public place." They can only decide what's there in the law.
So to some extent, I think it's wrong to get mad at the Supreme Court because, and at least don't get mad at them because they wrote this or they decided this, that they made it up, because they didn't. I think it's okay to disagree with them and say maybe I'm a little bit mad because I wish they would have agreed with the trial court judge, Judge Castro, who used to be the chief public defender in Ramsey County before he was a judge, but they didn't. So that's that.
You can
They're
be a
not going
little
to
miffed
revisit
at the
that.
short-sightedness of the
They're not going to
legislature.
revisit this probably ever. I mean, this will
Yeah.
never change unless the legislature changes that statute.
Right.
Or never, not not in the next 50 years. I highly unlikely that they will ever look at this again.
You saying there's not a lot of people running around out there just like shoving BB guns under their front seat, waiting to
No,
be pulled
I
over?
think, I mean, there may be, but the Supreme Court, the arguments have been made. Unless the legislature changes the language of the statute, they have interpreted it now.
Right.
And it's, I guess it's possible, like in 20 years, if all new justices are in the Supreme Court, they might say, well, the Minnesota Supreme Court interpreted that wrongly back in 2025. That's incredibly unlikely. I just don't think that's going to happen.
For a lot of reasons in Minnesota.
Yeah. But I think the legislature, they could change this law like next week or next month if they wanted to. And I think that's very possible. And in part, I personally think, going to the political, I think this is a political question. Like, as a community in Minnesota, what do we as a people want our laws to say? And sometimes it's really hard to break through the noise of the legislature, but the attention this case is getting might help do just that and get people to think, talking about public place. We don't like that. Well, let's change the statute then. This is what we can do. We can vent and blow off steam, or we can actually, focus our attention on the thing that's going to actually make it change. Like this month, we could pass the statute and make the car a private place.
Right.
Which, that could be part of a wider castle law expansion, or it could be a real narrow thing like what I wrote in my article. Just drop in a motor vehicle into the list of things that are not part of a public place. That would be incredibly narrow, but that would do the trick in terms of this case. That would change the law that this case made.
As we look at this, and like I said, I knew as soon as I saw this that I wanted to talk to you about it, and I had to get over my initial gut reaction because I wasn't as familiar with this as I would like to be, and I started to read about it more, and I read your piece on this. When you look at it from the perspective that you are saying, look, everybody take a step back, sit down, take a deep breath, and understand that there again, if there's frustration to be had, it could be a little bit with Supreme Court, could be some on the shoulders of the legislature for not having the foresight to think we'd better make sure this is as clear as possible. All that aside, when you look at the aspect of driving that in as you refer to it as the motor vehicle exception to the Fourth Amendment, do you find the court cases and the precedents that have been kind of or not inserted, but that they used to insert that exception to the Fourth Amendment, do you see that becoming a bigger issue going down the road, or do you think that's so well established now that it'll be hard to overturn that aspect of vehicle searches?
I mean, I think when it comes to search and seizure law, there is a phrase that is very powerful and very important. What is a reasonable expectation of privacy? So that comes up in the context of many different types of searches. So this could be like the police looking in the window of your house or jumping over your fence. Is your fence, do you have a chain link fence that's like 3 feet high? Or do you have a wooden fence that you can't see through that is 7 feet high that you can't see over without like getting on a ladder or maybe jumping over? So if the cops jump your fence, is there a difference? Do you have a reasonable expectation of privacy? Or if you have no fence at all, do you have a reasonable expectation of privacy? If the general idea there for the courts have said, if the public can walk through your yard of your house, why can't the cops? The cops are people. So if the general public can do something, then so can the cops. You can't
Right.
complain that the cops violated your privacy if anybody can do that. Anybody can walk through your yard. If the neighborhood kid cuts through your yard for a shortcut,
So can the cops.
so can the cops. Yeah. But if you build a fence, then the neighborhood kid can't do it without jumping the fence, probably won't do that. So you've created a greater expectation of privacy by building a fence. So if you put like maybe tint on your windows, maybe you could, the same kind of argument, but now window tint's illegal if it's beyond a certain degree in Minnesota. So there's a lot of issues like that. Or if you have curtains on your windows, or I've had cases where I had a marijuana case where the cops were in a helicopter using infrared filters to and telephoto lenses and infrared filters to see marijuana growing on my guy's farm. So I won that case because there was a U.S. Supreme Court case called Kylo, Kyllo, that
Mm-hmm.
said the cops cannot look through the walls of your house with an infrared scope or binocular and see you walking around naked in your house because the general public doesn't do that. And normal people, the average person, has a quote reasonable expectation of privacy that people aren't looking at you walking around naked in your house with infrared binoculars. So therefore, the cops can't legally do that without a warrant. And that's how I won the helicopter case where they used infrared to drop down and see marijuana growing. So it's very easy for them to see marijuana distinguished from other types of plants by using the special filter that they used. I forget which type of filter it was, but so it goes back to what is a reasonable expectation of privacy, and that is a culturally defined thing.
Right.
So it's not about, you don't have to be a lawyer. In fact, it's probably better if you're not a lawyer, really. I mean, what does your
Says the
average
lawyer.
what does your mom think? What does your cousin think? What does your neighbor think?
Right.
What does your kid think? What does your high school kid think is reasonable to expect privacy? Like if I'm in the shower naked, I don't really expect people to be looking at my private parts. I think that's an invasion of my privacy. Um, especially when I have the curtains drawn and everything else. So but they're out there with the infrared, like look at that. Wow, this guy needs to wash a little bit better.
Yes, do a better job, man. Do a better
Yeah,
job.
come on,
You know,
step it up a little.
So,
So when it
so
comes
there's
to
that.
this idea that the inside of a car is a public place, the fear is, well, could that leak out, and could that kind of affect the general cultural idea of how safe, how private do we feel inside of our cars? We like to feel safe. We like to feel like we have a private space, that we're protected, that we're not in a fishbowl. Um, is it reasonable to believe that or not? It kind of depends on if everybody lives in a glass house, maybe it's not reasonable to expect privacy inside your house. But
So one of the arguments that I've heard people making is like, well, if my car is, according, I'm saying it the way they're saying it. According to the Supreme Court of Minnesota, if my car's in a public place, that means somebody can just run up to my car and jump in and sit down whenever they want because it's a public place. And
no, that is incorrect. They're not saying that though. I mean, if they were saying that, that might be a big concern, but they didn't actually say that. So that's the flaw in that argument. Like, well, wait a minute, they didn't say that though. What? It's like, if fish could if fish could travel to the moon and back in 5 minutes, what would that be like? I mean, I don't know, but I don't think fish can fly to the moon and back in 5 minutes. So I'm not going to spend a lot of time thinking about it. They didn't say that. They didn't say that. They didn't say that people can go inside your car, that it's a public. What they said was that if you carry a rifle, a shotgun, or a BB gun inside of your car, and your car is located on a public place, like a public roadway, that you need to have a permit, or you need to have it in a zipped
properly
or
carry it.
snapped case,
Yeah.
a secured closed case, or it needs to be unloaded in the trunk, or it needs to be unloaded in a sealed case, or it needs to be in the trunk. One of those two things, or those three things.
And the
Either.
argument that you're making is not a defense of the Minnesota Supreme Court. You've already said like you do not agree with what they decided because you don't think it's reasonable. You don't think it's a reasonable opinion.
Well, I mean, I agree with the trial court judge, Judge Castro. I think his
Mm.
opinion, if I was on the Supreme Court, I think I would have said what he said, because the statutory definition is ambiguous. It doesn't mention motor vehicles at all.
So
And
err on the
therefore,
side.
I would say, I mean, I feel like my motor vehicle is a private space. And I think the reaction that we're seeing in the public, this case is getting a lot of public discussion right now, because I think most people feel surprised, like, oh my God, what do you mean my car is a public space? That's not right. People don't agree with that. That's my read of it anyway.
I guarantee you the Supreme Court justices believe their cars are private places. I guarantee.
Well, right. But I mean, I guess the real issue is, for the purpose of this statute, in terms of carrying a weapon or a BB gun. I don't think a BB gun qualifies as a weapon, but it's listed in the statute. So
Right.
a firearm or a BB gun, if you have that in your car, for that purpose, is it a public place or not? And they're saying it is. If you're on a public roadway, if you're parked, in your driveway, in your garage, I assume that's not. I'm going to presume for now that that's not a public place, because it's your private property, and that private property is mentioned in the statute. So I think, like what we talked about earlier, I kind of see it as, think of the car as being invisible, like Wonder Woman's airplane, the invisible airplane.
Yeah.
Except now it's a car. It's a car.
So
It's
many
Wonder
people do
Woman's
not get that
invisible car.
reference.
So if the car is on a public place, then the stuff in your car is in a public place. It doesn't matter if it's in your car, because your car is invisible. It's not really there. But if your car is parked on a private place, like the things listed in the statute, or like in your garage inside your
Right.
house, well, then that's a private place. The car doesn't matter there either. So the car is irrelevant. It's all about where your car is, not the fact that it's inside your car. So that's the Minnesota Supreme Court's view of it. And, we are stuck with it. So if I'm a lawyer, so I lean towards pragmatism. I'm not going to beat my head against the wall for no purpose. I'm
Right.
going to beat my head against the other wall that actually is made of thin drywall, the one that I could break through, which is the legislation. We could
Right.
change the statute just by getting the legislature to pass a bill.
Do you and I didn't even think of this until just a couple of minutes ago. Do you think that if the legislature is able to go in there and get this changed and amended which that's a whole other um, political question is whether or not they can actually get this changed now with all the
Well,
attention that's
they
on it.
can do it. The question would be,
Will
do they
they?
have the will to do it? Right.
Yeah, to fight it out
And they
on the
will.
floor.
I believe they will have the will to do it if we, the people, pressure them.
Right.
That's what. So
Do you think them
yeah.
changing this now and putting that definition in and including your car as a private place according to that statute, do you think that actually opens up the door for a a better definition of what a reasonable expectation of privacy is in future cases? In varied ways?
I mean, in a kind of in a indirect way, I guess is the best way to say it. Not directly. No, it doesn't.
Yeah,
But
nobody's going to be able to point at this statute and say something that's unrelated to the firearms, and it's like, oh, that's a private place.
I mean, it wouldn't be directly related one way or the other. It doesn't really affect Fourth Amendment law. But I think the broader question is in a more diluted way. It's like if you drop a bucket of water into a lake, does that change the level of the lake? Yeah, probably in a way that you can't really perceive. Be hard to
Yeah,
measure it, but theoretically, I think if you were a physicist, you would probably say, yeah, it does. There's like one molecule higher level in that lake now that you dumped a gallon of water into a lake, you know? So it's kind of that kind of thing. But so yeah, it may have a little bit of an effect, but it won't be huge. I think the big effect would be that if you are like, let's say you like to shoot and you're going to the gun range with your handgun and you're going to go practice and shoot some targets, which is a fun thing to do. You're going to buy some ammo, you're going to stimulate the economy, you're going to pay like $30 to the gun range guy, and you're going to burn some gas, you're going to have a little social event with your friends at the gun range, which a lot of people enjoy doing. So you've got your gun in your car and you forget to put it in your trunk, or something like that. um, well, right now, they can arrest you and throw you in jail and convict you of a crime. I mean, most people that I'm a criminal defense lawyer, I can tell you that most people that get charged with crimes did not believe they were committing a crime at the time. They had no idea. The vast majority. They thought they were, you know, I said, why didn't you talk to the cops? Well, of course I talked to the cops. I was innocent. Why wouldn't I talk to the cops? Oh, so you thought you were innocent. That's great.
so how'd that work out for
Yeah.
you?
So here you
But
are.
so what you're hearing today, folks, from Tom, and I know he had no problem with this. You don't consent to a search, and you don't talk to the cops. You're never innocent. You-
Well, I mean, I talk to the cops. If I get pulled over for speeding, I'm going to talk to the cops. If they ask me, why were you speeding? I'm going to look at them like, officer, I'm not sure why you pulled me over, but whatever it was, I'm really sorry. I'm such a bonehead. Like Tim Walz, talking at the debate, I'm a bonehead, but I don't know why. I don't know why I'm a bonehead, but I'm so sorry. So I'm going to kiss your ring or whatever, but I'm going to show you respect because I don't want a ticket, but I'm not going to admit shit. Sorry. Oops, did I say something? Sorry about
no,
that expletive there.
no. I mean,
You can bleep
I've
that
said
out later, right?
I've said far worse. Trust me. Well, I'm gonna because we're coming up on an hour, and I think we've hashed it out. You since you brought up the speeding thing.
Well, 'cause there's one more thing more
Oh yeah,
related
go ahead.
that I wanted to touch on is the whole BB gun thing.
Yeah.
So I have another article on my website. I got to promote myself a little bit here, right?
Well, your link to your website will be in the
So
show notes.
I've got the article on this case, which is the what is a public place. I have an article like what is a public place under gun laws.
Hmm.
We've been talking about that. You showed it earlier. I have another article on my blog about BB guns in Minnesota criminal law. And I think that's kind of interesting because there are cases that a lot of people have heard of that say Minnesota Supreme Court has said for purposes of prohibited, there are people who are prohibited from possessing firearms. So people with like a prior felony or felony crime of violence. That law applies to firearms, but does not talk about BB guns. So if I'm a convicted felon and I still can't have a firearm. Some can actually after a while, but some can't. Depends on the crime that I was convicted of. But I can possess a BB gun in Minnesota. I don't know why I would want to, but just maybe I shoot a squirrel or something, right?
You're asking for trouble. One.
Yeah, but so I guess, if I'm prohibited from possessing a firearm, maybe I want to go hunt squirrels with a BB gun because it ain't much, but it's all I got, right? Without getting in trouble. But people have heard of that. So the Minnesota Supreme Court said, no, a BB gun is not a firearm, which is true. It's not a BB gun is not a firearm. It's literally not. And so, but the problem is that guess what? There are criminal laws in Minnesota that actually mention BB guns, air guns, and replica firearms or firearm replicas. And then there's exceptions for antique firearms, which is another topic I don't even want to get into right now. But the BB gun thing, so there are situations where BB guns are specifically listed, like in schools and things like that, where you might expect, kids have BB guns, young people. Like when I was a kid, I had a BB gun, like a lot of people, kind of learned on BB guns. But so there are laws that say it's a crime to have a BB gun. And guess what? This one that we're talking about in this BB case, is an example. It's a lot of times people talk about this case, they don't mention BB gun because it's not really the main headline, the number one interesting thing about it. But it is interesting, I think, that this case was a BB gun case. So yes, in Minnesota, I'm here to tell people, I want people to know, spread the word. It can be a crime to have a BB gun in Minnesota. Whether that should be the case or not, that's not up to me, right? But I'm here telling people, look out, watch, heads up.
Be careful what you do.
So if I'm a felon and I can't have a firearm, I can still have a BB gun unless there's a law that says I can't have a BB gun, like this law that says you can't have a BB gun in your car unless you have a carry permit, or it's unloaded and cased, or it's in the trunk. So I have another article on BB guns in Minnesota criminal law.
Yeah. And you also have one about the case you just won not too long ago about homemade guns and serial numbers.
Yes, that's true.
Yeah.
Yep.
That was actually literally a precedent-setting case here, because there's another one another case in Minnesota that was waiting for resolution in that case.
Yeah, there is a case in front of the Minnesota Supreme Court right now. We're waiting for it. It's already been argued. It's not my case, though. I won a case at the trial court level, and therefore we didn't need to appeal it. I have other cases right now where we're kind of waiting for this Minnesota Supreme Court case to get decided, because it is another statutory. Well, there's two levels of that case. One is statutory interpretation, and on that issue, the Minnesota Supreme Court will be the final word. Then the other issue is the Second Amendment and Bruin. And on that issue, the Minnesota Supreme Court will not be the final word. We will be able to appeal that to the federal courts.
Real quick, I want to hear your thoughts on this before I kick you out to enjoy your Sunday. I don't know what esteemed criminal defense attorneys do on Sundays. I'm probably take a break from so that they can go into their Mondays ready to fight. So last year, Minnesota law went into effect that says law enforcement officers can no longer, in a traffic stop, pull you over and ask you, because it's now against the law. Against the law, they cannot ask you, do you know why I pulled you over? An interesting thing in that law, there are no enforcement teeth. So it's technically against the law, but there is no penalty for it. What does that look like for, and I know it's probably never going to happen, but what's that look like for the guy who says, Your Honor, I have dash cam video of the officer approaching me. The first words out of his mouth were, excuse me, Mr. Smith, do you know why I pulled you over? What's that do for a guy?
Yeah, that's a good question. That's an interesting question. In law school, there's a lot of aphorisms that sound really smart, I I took note of some of them, and one of them, it goes like this: "Without a remedy, there is no right."
Yes.
And so without a remedy, there is no right. And I think of when I was a little kid walking around the block and some big kid wants to push me down because I don't, do what they want me to do.
Right.
And I say, well, you can't do that. That's not fair. And the big kid goes, oh, yeah? What are you going to do about it? Squirt? So, that's when if they're bullying you, you got to like punch them in the nose and break their nose, even though they're bigger than you. Because
Tom
even
is
though they
not
beat the
advocating for violence, by the way.
Even though, well, like I think there's a video I saw on YouTube, Johnny Depp's video about his mother's advice, what to do if there's a bully in the schoolyard. She basically says, beat the crap out of him.
Yeah.
And even if he hurts you more, he'll never do it again, which is true.
Right.
So there has to be, without a remedy, a legal right is meaningless unless you can do something about it. And that's what the court system is all about. I mean, the judges and lawyers are well aware of this. And this is something in law school, like the first week, hey, without a remedy, there is no right. So a right without a remedy is a joke. It's like the Chinese Constitution, which is
Yes. Yes.
when I was in constitutional law class in law school, we read the Chinese Constitution. And I was like, wow, this thing is better than ours.
Right.
Chinese people have more rights than Americans do. This is crazy. This is great. The problem is the courts cannot limit the government in any way, shape, or form.
Right.
So there's no judicial review in China. So it's just meaningless words. Doesn't mean a thing. But in the United States, the courts can slap down the government if they violate the Constitution. So,
and vice versa, by the way, folks.
Yeah. So going back to your question, if the cops say, do you know why I pulled you over? If I have that case, I'll tell you what I'm going to do is I'm going to move for dismissal of that charge, whether the judge grants it or not.
Right, because that's your attempt at remedy.
Yes. So I'm going to request the best remedy, which is complete dismissal. I'm going to say, Judge, this is a direct violation of the law. The officer knows darn well they're trained in this. He violated it. This is an egregious violation. They're not allowed to do this. The only effective remedy to deter this kind of behavior is dismissal. So please dismiss the charge based on that violation, that clear and blatant violation of the law.
Of the law.
It had to be knowing. It wasn't like a mistake. Oh, gee, I didn't realize. It's not a mistake. They know, they know better. They know the law.
He now knows the law says you can't ask that question.
But whether a judge agrees with me on that, I don't know yet. That doesn't happen. So it hasn't come up yet. It's a relatively new law, so we'll see.
Yeah, well, I mean, and what are the odds that somebody like you is going to get called to argue a traffic?
I mean, if I was a cop or if I was training cops, I would simply not do that because you don't need to do that. It was a cute trick until they couldn't get away with it anymore.
Right.
Now why take the chance? Just don't say it. There's other ways. There's 9 ways to skin a cat at least, right? So you don't need to use that one. You can use the 8 other ones if you're a cop.
Yeah, precisely. I was just curious because I saw that too right away when I read it. I'm like, there are no teeth to this. There's absolutely it doesn't do you. The only argument would be, and that's where my brain went was.
So instead of if you're
Your Honor, throw this out. The cops broke the law from the very second.
If you're a cop, instead of saying, "Do you know why I pulled you over?" Why don't you just say, "So, are you in a big hurry right now? What's going on?"
Right. Exactly.
Because that's not the prohibited language, but it's almost the same thing.
Exactly. Well, Tom, tell everybody once again, where they can find you on socials. Your links will be in the show notes, but tell everybody where they can find you. And
yeah, my website is. Oh, go ahead.
All about hiring you.
Okay, so my website is GallagherDefense.com, and the toughest part of that is spelling my last name. But I think if you do a voice search, it'll come up fine on a voice search. GallagherDefense.com, and my blog, and I've got many pages covering a lot of topics there. There's a lot on the court process, every step of every court appearance, what it is, what it means, a lot on different types of criminal charges, on defenses, on evidentiary issues, like we talked earlier about stage one and stage two. So evidentiary issues are stage one, and then stage two are the criminal laws they have to prove that my client violated, and then there are defenses to those. Then I have all those covered, as well as I have a blog that gets into more timely issues like the BB gun in Minnesota criminal law or the public place
Right.
or different aspects of gun law. I have a lot of stuff on gun laws and self-defense there. But and then on social, I'm on Gallagher Criminal Defense on Facebook and at Tom Gallagher Law. That's my work X, or formerly known as Twitter, account.
Yeah, we just call it Twix here.
Okay.
People are like, "What do you, I don't get it," and I'm like, "Twitter, X, Twix, which side, left, right?" Never mind. It's
X, formerly known as Twitter, like Prince.
yeah, yes. Oh, well, Tom, I really appreciate your time on this Monday, not Monday, Sunday. So, but now I'm gonna have to go back through and listen to it after we've talked now, and like think about what other threads we can pull in the near future because there's a lot that this is what happens is a lot of times there's things in conversations that others will never talk about, but now my brain's thinking about them, and I need sources like you to air those out. So
Yeah, I think this public place thing, this is getting a lot of press right now,
yeah,
a lot of discussion, a lot of news media, not just in Minnesota, but all over the country, maybe around the world. People are talking about Minnesota. How come they think a car is a public place? What is going on there? So
yeah,
it's a timely
that's
topic.
it's I I don't think it's going to have any groundbreaking implications in the long run. I'd like to see the legislature step up and do the right thing and fix this verbiage because I think that would be a great um, remedy here, so to speak. But I do think it's opening up the conversation in a way that hasn't been opened in a long time. So, and I really appreciate your level-headed approach to it because, like I said, my first gut reaction, without having read into the case at all or read anything out of the case at all, was to go, "Whoa, wait a minute, wait a minute, wait a minute. This sounds dangerous." And I think there could be if it were decided on a Fourth Amendment perspective, but now we know it wasn't.
And I
So
think with all the public discussion right now, it's really interesting for me to observe what people think, like people that aren't lawyers think about this stuff. And I've noticed that it's not really what I'm hearing people say in the discussion in social media and elsewhere. It's not really a left versus right. It's not a Democrat versus Republican kind of
right.
thing. There's people on both sides of the left right uh, traditional continuum that feel like, you know what, my car is not a public place.
Right. And it hits, like you said, it hits people across the political spectrum. It hits on a nerve that a lot of them aren't used to having touched in uh, a non left versus right perspective. It actually is hitting them on a very foundational, fundamental, philosophical nerve of, whoa, wait a minute, that doesn't feel good at all. We should all be able to agree on this.
Right.
So busy week ahead of you.
Always.
Always, he says. So get in now, folks. Get in early. I There's no discount for saying you know me. He might actually charge you more. So, well, thank you for your time, and I will let you go do what you're going to do, and I will close up shop.
All right.
Thank you,
Great
sir.
discussion. Thank you.
Folks, this is why I love having Tom on. He's the kind of guy you want on your side because he thinks through the issues. Uh, don't go to your buddy and say, "Do you think I should fight this in court?" You know, and especially if your buddy thinks exactly the way you do, because then you're just in an echo chamber, and your buddy's probably going to give you bad advice. And if you work as your own lawyer, what do they say? The person who represents himself has a fool as a client. So I strongly suggest that when news like this breaks and you see these salacious headlines come out and say the Supreme Court says Minnesota Supreme Court says your car is a public place, have your gut reaction, but take a step back and breathe. And I, my friend Kevin knows that. So I told him I was kind of having the same responses that he was, and kind of we were running through all the scenarios of what this would look like. And then I said, I've already reached out to my friend Tom. I've had him on before, and we're going to talk about this because I read his articles, and I really feel like Tom's nailing it, and he does. He absolutely nailed it in his articles, and they will be linked in the description of the video. You will also be able to find links to Tom's website and to his social media. He is a phenomenal follow on X and on Facebook. If you can get him to pop up in the algorithm, every time I share one of his articles, they send it. They send it back to me saying we're not going to allow you to share this because it looks like you're trying to do a scam, and I'm like, okay, I get it. He's a lawyer, but that doesn't mean he's he's a bad guy. I mean, I know there's a playwright out there that said something about what we're supposed to do with all lawyers, but we won't. That's not how I feel. It feels like that might be Facebook's problem, not mine. But Tom is an ally in the fight for liberty, and I mean that. I've seen this guy at multiple events. I've seen him at Defend the Guard. I've seen him show up to numerous places to stand on the side of the Constitution and stand along with people who, as they say, politics makes strange bedfellows. Well, Tom's that guy. He stands for what's right. He stands for what's in the Constitution, and he doesn't go off half-cocked and have like these harebrained responses to things. He approaches them from the perspective of what is right, what is wrong, as you heard him say, and what's our remedy. And those are key questions. It's very easy, and I'm not a scholar. I'm not Tom, and so I can get away with it sometimes. I can get away with saying things that aren't 100% accurate um, because I have people in my life that I can read and rely on who are contemporaries today. I'm not just looking back at just what our forefathers said. I'm looking at people who are alive today, and they're reading these things, they're studying these issues, and they're approaching them with reason and logic, which I try to do, but I fail at far more than I care to admit. That's Tom. He approaches these things from a very measured and reasonable perspective, and he's an observer. And I watch him as he's watching what the public's saying, and I rely on him a lot for direction. He doesn't know that all the time, so I do rely on him for that. So, folks, thanks for stopping in for this actual season premiere of TC and Friends Monday Night Musings. I'm looking forward to what we have coming down the pike. Like I said, be paying attention to what we talk about with Pam's story and how she was treated by Wabasha County Social Services and Plainview PD. As you guys know, some of the stuff that I've already commented on there, I've been pretty upset about. Very, very angry about how she was treated. It the lady was done dirty, and there is no remedy for her now. It's we're fighting and we're fighting and we're fighting, but the victory in this now will be preventing from what happened to Pam from happening to anyone else. That's one goal. If we can get remedy for Pam down the road, that would be phenomenal. But I know Pam's concern is, how do we stop this from happening to other people in Southeast Minnesota? So don't think that you live in small rural Minnesota or small rural whatever state you're in, and these things can't happen to you. That there's only corruption and dirty things and whatnot only happen in these big cities. It's only on TV. No, it's not. It's not. Corruption and dirty politics happen in every jurisdiction and every locale, and it never changes until we do something to change it. Until we take up the fight, take up the mantle of the cause of other people who have been hurt and harmed by a system that has forgotten its place. So Once again, shout out to the show producers, the Angry Vet from here on YouTube or from YouTube, and IMAT from Subscribestar, and to the one who goes unnamed because she wanted to remain anonymous. You know who you are and you know what you've done for the channel. Thank you very much. All the other channel members and supporters, thank you for what you do. If you want to join the channel, there's a little button down there that says join. Hit that. Send a super thank you or a super chat anytime that I'm on. And if you want to take part in my fight for freedom, you could tune in for a couple hours a day and watch the Freedom Flock. My city wants me to get rid of my chickens, and I'm saying, no, I'm not getting rid of my chickens. And here you go. You can watch them. There you are. See, look at how dangerous my chickens are. See, that's what we do. That's what we do here. So, my friends, until next time, fight. As my friend Monica made this for me a couple of years ago now. Fight for your liberty. It is yours. Fight for your freedom. It belongs to you. And until next time, Sic Semper, Tyrannus.
We are go for liftoff in T-minus 30.
Stand by for further instructions, Minnesota Black Robe Regiment.
Secondary guidance systems engaged.
Minnesota Black Robe Regiment, it will be on my mark.
All systems are a go. All systems are a go.
Minnesota Black Robe Regiment, you are over the target. You are authorized to fire at will.